Be ready. 5 seconds. Start. Further, so far as the judgment cited by the respondents in Civil Appeal number 331 of 2014, we are of the view that the same has no application on the facts of the present case because the appellants in that matter are nowhere connected or concerned with the appellants in the present batch of cases as contended by the appellants. In that matter, the aggrieved persons have not challenged the acquisition proceedings, rather they accepted the acquisition but filed references for enhancement of compensation. The appellants therein have accepted the compensation in the year 2001 itself after the passing of the award, and their possession have been taken in the year 2001 itself by the authorities concerned, whereas in the present batch of appeals, the appellants are still in possession and they have not accepted any compensation for their acquired land. Secondly, the impugned judgment in the present appeals is 2 years after passing of the impugned order in CA number 331 of 2014. Therefore, the impugned judgment of CA number 331 of 2014 is totally different from the impugned judgment in the present batch of matters and are in no way connected to each other. After referring to the aforesaid decisions with reference to the facts and circumstances of the case on hand, we are of the view that physical possession of the land belonging to the appellants have neither been taken by the respondents nor compensation paid to them, even though the award was passed on 6/8/2007 and more than 5 years have elapsed prior to date on which the Act of 2013 came into force. Therefore, the conditions mentioned in Section 24(2) of the Act of 2013 are satisfied in this case for allowing the plea of the appellants that the land acquisition proceedings are deemed to have lapsed in terms of Section 24(2) of the Act of 2013. The said legal principle laid down by this court in the case of Pune Municipal Corporation and other cases referred to supra with regard to the interpretation of Section 24(2) of the Act of 2013 are applicable to the fact situation in respect of the land covered in these appeals for granting the relief as prayed by the appellants in the applications. From the aforesaid decisions, the legal position that emerges is that when a repeal of an enactment is followed by a fresh legislation, such legislation does not affect the substantive rights of the parties on the date of suit or adjudication of suit unless such a legislation is retrospective and a court of appeal cannot take into consideration a new law brought into existence after the judgment appealed from has been rendered, because the rights of the parties in an appeal are determined under the law in force on the date of suit. However, the position in law would be different in the matters which relate to procedural law, but so far as substantive rights of parties are concerned, they remain unaffected by the amendment in the enactment. Stop. Thank you.